Great. Hi, everyone. Welcome to our Cyber Settle session on online arbitration. That's a joke there. Welcome to our Cyberweek session on online arbitration. I'm very excited to have the prestigious panel, and I see Amy has just joined us. And I'd like to start with introductions, but I'm going to force my panelists to introduce themselves, because then they don't get that, traditional 3 minutes of people waxing on and on about how incredible they are. I will say all the panelists are incredible, but that's all I'm going to say. So Sophie, please say a little bit about yourself first.
Thank you very much. It's a great pleasure, as always, to be here with Colin and other enthusiasts in the field. My name is Sophie Nappert. I'm a Canadian. I'm based in London. I am a full-time arbitrator in matters that had very little to do with technology until 2016, when I started to get interested in this field. In 2019, I completed a blockchain strategy program at the University of Oxford, and in 2021 I founded OArb, which is an online dispute discussion group on Slack on questions to do with the interaction of technology and dispute resolution, but not only crypto as well, regulation, and we aim to be cross-disciplinary, so lawyers, of course, but not only Colin, developers, coders. It's very important to us to have that dialogue. Thank you.
Well, I'm going to make you talk more about Arbitech in a minute, because I think it is really an incredibly vibrant home for a lot of the discussions we're going to be dealing with today. But first, let me go to Paul. Paul, say a little bit about yourself.
Hi, thanks, Colin. Paul Cohen. I am both an American lawyer and a barrister. I act as counsel exclusively in a bunch of arbitrations. And like Sophie, in those arbitrations, typically they have precious little to do with technology itself. But as with Sophie and I became interested in this field around a similar time and have written several articles about technology and arbitration and the like over the years. And we recently started or held, I should say, a conference at which you spoke, Colin, FOTA, Future of Technology in Arbitration, which hopefully will be a recurring theme and a recurring conference. So all these issues are of interest to me. I should probably note, and it'll probably become clear later, that Sophie and I, despite loving each other to death, have diametrically opposite opinions about blockchain.
Oh, great. That's going to make for a juicy discussion.
That's just one of the things on which
among other things.
Well, I can't I'm almost tempted to dispense with the rest of the agenda and let the two of you just go at it, because that'll make for a really interesting session. But first, before we do that, Neil, can I ask you to introduce yourself, please?
Yes. Hi, everyone. It's wonderful to see you all here. So I'm Indraneel Gunjal, or Neil for short. I'm a lawyer from India. I'm working with Colin and Professor Amy at arbitrate.com and mediate.com. I did my master's in international law and dispute resolution from Stanford. That's where I met Colin and Amy, and I've been working with them almost ever since. So it's been a great journey. Before that, I worked in the federal government in India on pretty much dispute resolution, working on international commercial disputes, investment arbitrations, trade disputes, and the like. And I've been interested in this part of law since I started law school back in India. So it's very exciting to be here. And I enjoyed learning more about technology from both Colin and Amy. And I have, of course, been aware of the work Sophie and Paul have been doing, and pretty keen on discussing some of the technology stuff with them too.
Fantastic. Thank you, Neil. And Amy, introduce yourself, please.
Yeah, so everybody, thank you so much. This is just a fun group to be part of, so I'm really appreciative of this group. So I'm Amy Schmitz. I'm a professor and chair in law at the Ohio State Moritz College of Law in Columbus, Ohio. And I've been teaching dispute resolution and arbitration in particular for over 20 years. I think I'm at like 23 years now. And I'm very, very interested in the role technology plays. Many years ago, I wrote an article, Drive-Through Arbitration in the Digital Age. And it was very early on. And in fact, that's how I met Colin, because it turns out that's ODR. And I was very interested in ways that we can use technology in order to make arbitration better, more fair, more efficient. And now, of course, we've got metaverse, we have blockchain, we have AI and data analytics. And so it's just becoming a more and more vibrant area all the time. In fact, I host the arbitration conversation for anybody listening. You might want to check that out because I had the pleasure of interviewing both Sophie and Paul as part of the arbitration conversation.
Great. We should put links to those too. So in case the session gets boring, you can go watch Amy have a conversation with Sophie and Paul. You know, the last introduction, and I know I didn't make you an official panelist, Debbie, but I do want you to introduce yourself and just talk a little bit about your background and DRD.
Sure. Thank you, Colin. I'm Debi Slate. I'm the co-founder of Dispute Resolution Data. And my background in terms of ADR is with the American Arbitration Association. I was with them for about 14 years. Prior to that, I started the first mediation organization in South Carolina, where I now live again. And so that is, so I have a history of mediation and then in arbitration with AAA. I was in charge of online services. And so I was involved early on in online dispute resolution, as well as creating web file and some of the tools that now people are using just on a regular basis. But so now I'm involved in data analytics. Dispute resolution data examines the data from international commercial arbitration and mediation cases. And we have 20 participants now in terms of the database across the world of institutions representing their data and looking at the data for concerns about budget, time, and just looking at what's going on in terms of a benchmark around the world with different kinds of cases, 28 different case types.
Fantastic. Thank you, Debbie. And I don't know how much control I'll have over this conversation, but I do want to steer it back to that data discussion because you and I have been having some really interesting conversations over the past few weeks. But let's start out with a level set. Now we have Ethan here, which I'm not going to make him introduce himself because everybody knows Ethan. And Ethan invented the term, obviously, ODR, that we all use so seamlessly. But Amy, I think you were the first person to coin OArb. I think I have not found anyone who used that term before you used it. So can I just start with you? What do you think OArb means? You know, and how has it changed? How has the meaning of OArb changed since you first coined the term?
Yeah, I mean, the reason I sort of parsed out OArb as opposed to ODR is because it is different. It's a different animal. It's arbitration. We're usually talking about arbitration where it's final and binding per an arbitration agreement. You have the New York Convention applying to international. You, of course, have the Federal Arbitration Act here in the United States and similar laws in other countries enforcing arbitration. And so it's got its own animal. And I felt like it was something different from other forms of ODR. And so but now I like the question about sort of a moving target because it is. You know, in the beginning, I think it was really about the kinds of stuff you were doing, Colin, even at eBay, you know, and thinking about just communication or having just using a communication platform and having a final and binding resolution by another third-party neutral who would be available via email or some kind of an online chat or Zoom, of course, or some kind of a video chat platform. But now I think it's such a richer environment. There's so much more that we need to be talking about with respect to OArb and what it can include. You know, you can build in solution explorers, data analytics, using even perhaps AI as more and more data is created. I love the discussion you're having with Debbie about the data. You know, what could happen? What could the future look like? And of course, metaverse and thinking about what that could look like and when that might be available for arbitration. And we even see in these kind of areas like the Facebook Oversight Board, you know, that's a type of arbitration, which is really quite interesting. And the Digital Services Act and where that might go in creating online arbitration propensities and opportunities. And of course, blockchain and what that means with respect to arbitration. So I just think it is a moving target because it's growing and what we consider to be part of that universe is definitely it's a richer environment than it was 20 years ago.
You know, it's interesting because I do feel in the ODR field, we had the ADR field that existed before, and then there was the creation of this other field. ODR, and we sort of had our own theory, and we had our own events, and we had our own conversations. And eventually what happened was I kind of feel like the train tracks merged, because ADR started to use more technology, and then it was like, wait a minute, what's this ODR thing? And now it's kind of, you can't tell it apart. But I don't feel like that's what's happened in arbitration. I don't think that there was an OArb field separate from the arbitration field. I just feel that now arbitral institutions and arbitrators are starting to use more technology. So it's almost like this concept that you came up with is coming true, but it's not like we're merging the train tracks. It's just, this is a development of arbitration. I don't know if anybody else feels that way, but that's kind of my sense.
Well, and also I think in certain areas and contexts, we're seeing more of it. And then some people are going back to in first person and insisting to sort of not be on the OArb train track, right? And so it's kind of interesting to watch that develop. I'd be curious to hear sort of other thoughts throughout the world and thoughts about that question.
Yeah, absolutely. Well, I want to go to Sophie next. And Sophie, I want to ask you about ArbTech. I mean, I thank you so much for letting me be a part of it, because, you know, as a non-arbitrator and a non-lawyer, I don't know, it's like, what's Colin going to add? But
precisely, yeah,
exactly.
that was your ticket in.
There you go. But I have found that the conversation there to be so fascinating, and the community you've built is so young and so vibrant and so focused on the future of arbitration. It's a community unlike any other that I've participated in. And I just wanted to know, you know, what was your aspiration when you created ArbTech, and, you know, where do you think it's going? You know, where do you, your sense of the group in essence of where their interest lies? You're
like my website developer. She wants me to look at the crystal ball and tell her what the business is going to be. I mean, first of all, ArbTech is not a business. ArbTech is very much a convening place. And the genesis of that, of course, is my decade moderating OGMID. When I was doing that, I realized very quickly the power of community. OGMID became the place that it was because of the quality of the moderation, and I'm saying this without any credit to myself, because we were a team and we made sure that the discussion remained at a high level. But it was the thoughts that this attracted, and I realized very quickly that if you are passionate about a topic, whatever it is, and you want to keep the discussion at a high level, there are peers out there who are interested in participating, who will come forward, who will share, and that in itself creates a community. So after 10 years, I decided to hang up my skates, as we say in Canada, and to do something that it's .io.
Oh, sorry. I don't know why.
If you said no, it's because there's there's a tree company with that.
I think it redirected. I don't know.
No, that's fine. It's .io. Fair enough. Okay. Fair enough. And they are a fascinating tree company. Anyway, so I wanted to thank you. I wanted to create a community around the legal tech, or the intersection between tech and the future of justice, particularly dispute resolution, because this is what I know, but not only. And I was very keen to have, as you know, Colin, people who were not lawyers, who were, but because I think that I felt that the dialogue was siloed. There were lawyers talking to lawyers, there were coders, developers, you know, entrepreneurs talking to each other. But in order to, when you have peer-to-peer dispute resolution applications bubbling up, and we will talk about this later on, then you have to understand concepts such as, you know, equality of arms, due process, fairness, and how that translates in online, in a coding platform. And so that's why I wanted to have this discussion. So that's how we built it. It's a very young organization, started last year. We were shortlisted for the GAR Awards after 1 year of existence, which obviously is a great buy-in from the community, but also it does mean that we are growing. What we do is not only do we speak to each other on Slack, but we also put together regular events. We just had one this week on DAOs with experts explaining what are DAOs, why should we care about DAOs, what's the legal structure around them or the lack thereof, the stuff to make it intelligible to everyone. That we really want to have a conversation when it's, because I mean, lawyers are speaking jargon, tech people speak in jargon as well. We want to make sure that we understand each other. And we also obviously are media sponsors for and contributors to fantastic events around this space, such as FOTA, which Paul will talk about a little bit later. So that in a nutshell is what ArbTech is about. And if you're interested, please join us. Your voice counts.
Fantastic. And I'm going to go to FOTA to Paul and talk about FOTA in just a sec. But I will say it's interesting when I would say the first 20 years of my work in online dispute resolution, I didn't talk about arbitration. I talked about evaluation. And there were a lot of evaluative mechanisms that were happening in ODR. As I said, at eBay, we did millions and millions. I mean, almost more than 10 million quote unquote arbitrations per year, but they're not under the New York Convention. They're not binding. They're evaluative outcomes that a customer service rep looks at a case and renders a decision. And, Kyle was on the call too. I worked very closely with net neutrals. They provided essentially, arbitration processes, but they weren't formal arbitration processes. They were just evaluative dispute resolution processes. But I steered away from the term because to me, it felt like the ICC, it felt like ICDR, it felt like sort of the province of a bunch of, highfalutin arbitrators around the world. And if I use the term, I was nervous that I'd kind of get sucked into that and delegitimized. So that was why we said evaluation. Now, the thing that I love about ArbTech is it's so young, it's so forward looking. It's like, what can we turn arbitration into if we reclaim it back from that kind of rarefied air? And I think that Neil and Amy, when we started arbitrate.com, was the same thing. It's like, let's not think about what arbitration is today. Let's think about what it should be. How can we make it younger? How can we make it more innovative? How can we make it more diverse? And to me, ArbTech, that conversation feels like where arbitration is going.
Thank you. That's exactly what it is. And you're absolutely right that, and I mean, in all of the fora where I'm speaking about this topic, I say, and I actually, this is not being an alarmist. I actually think if arbitration wants to survive as a dispute resolution method, it has no choice but to rejuvenate and make itself. Doesn't mean that we have to scrap what we've got. There is a spectrum of disputes and horses for courses, as they say in the UK, but it can be a younger version of itself, more nimble, more responsive. That's what we're trying to promote. Yes, thanks.
That's great. Okay. All right, Paul, let me come to you because I think you are, you're sort of a truth teller in the arbitration field. You call it like you see it, balls and strikes. And I love the personality of your photo gathering. And I think it takes a little bit of moxie to put something like that on because there's so many different threads you have to tie together. I was wondering, A, what was the motivation for pulling that together? And B, because you were there for every minute of it, what's your takeaway? I mean, what now, how did it change your sense of how technology is transforming arbitration?
First of all, thank you again for showing up at 3 in your time at FOTA. So
as a cat in a hoodie, right?
As a virtual cat in a hoodie, which made a point. I think we're all trying to do somewhat the same thing or similar things and approaching it from different angles, be it the arbitrate, be it ArbTech, be it FOTA. And that is to say, we are trying to find the merge, the train tracks, or whatever it is that you were talking about. The FOTA angle sort of comes at it from the other way. So what we tried to do was to have a conference using the orthodox arbitration practitioners, the usual suspects of the big international arbitration world, who are used to participating in or adjudicating multi-million and multi-billion-dollar disputes in international arbitration, and to get them to meet partway with some of the folks who are doing technology, both in the context of, such as it may be, in those large arbitrations, and folks who are doing perhaps more interesting things in the online space or in the AI space. Really, I think that, again, I'm not sure how much, this is why I sort of agree and disagree with Sophie. I think that what we find is that there is still, and there remains, a massive disconnect between the older generation of arbitration practitioners. And when I say the older, I mean, people over 60, of which there are many. Nothing wrong with being over 60. I'll be there soon enough myself. But them and the folks who are coming into arbitration, international arbitration, have come into it recently, where you see an enormous amount of enthusiasm and uptake for the kind of technology that you see discussed in ArbTech and elsewhere. International arbitration is a bit of a strange beast by comparison to other fields of the law, in as much as it's sort of ruled and guided by old people. And again, I'm nothing against old people. I'm an old person. Let's stipulate that. Because take any other field, pretty much any other field of law, and it's sort of run, or I don't know what the word is, guided by a combination of dialogue between regulators, practitioners and clients. Arbitration, international arbitration, because it traditionally has this structure where you have these arcane rules and procedures that have developed because of arbitral institutions, and because you have a bunch of folks who practice as counsel first, and they sort of move on to arbitration as arbitrators, and they're the ones with experience. They sort of sit at the top level of the guiding force of what arbitration is. And because they sit there, and because the general aspiration of people involved in it is to be an arbitrator, it's not mine, but it happens to be most people's, you find that that's the biggest thing that you can do. If you're a litigator or a regulator, your aim is not necessarily to be a judge, but this is the case in international arbitration. So as a rule, we have an older cadre of people who, again, generalizing, are less au fait with arbitration. With technology. My apologies. Sophie is a large exception to this.
No. That's not what I'm saying. I think so. Sorry, Paul, to interrupt. I just thought. I thought, what would you say if I sort of put a gloss on this and saying that it is because arbitration has to do with decision making in high stakes disputes that it tends to be the older, more experienced.
Well, I think that's fair.
And of course, there's a generational aspect to technology. I completely get that, but I think we have to be fair in saying that the reason why it tends to be in the higher spectrum of age is just because users trust gravitas, right? And we are a service industry, right?
Yeah. But that's true of all. I mean, all dispute resolution is about decision making. It's just that the dialogue about how it works in other fields of the law doesn't necessarily tend to be run, as it were, by those that old level decision making, that older cadre of decision makers. Because there's the thing that irritates me about arbitration, international arbitration in particular, is that there is a gap between the actual users, the clients, and the folks who are deciding, the arbitrators, because they're at one level removed. In a sense, it's not the clients usually themselves directly who pick this out, right? And yes, I totally agree with what Jim has just said, is that because of the New York Convention, what you have is you have to abide by a certain way of reaching a decision, and so you tend to be conservative because you don't want it to be kicked out on New York Convention grounds and didn't fulfill the due process, et cetera. So I think technology lags because of that. And I think what's really interesting though is how, and this is what FOTA was trying to do, and I think ArbTech is trying to do, how we're going to import these technologies into a world that is really not terribly tech savvy, and that ought to be. That's the real frustration. Arbitration is so much more flexible in theory than court practice is. It is the place where we ought to be seeing all these changes, and we're not. And I wonder whether we'll just hit some tipping point between ArbTech and FOTA and what have you, where all of a sudden the lights switch on. Certainly with the the under 40s, for some reason I have the French word branché. What is it, Sophie? They're plugged in, right?
Yes.
But I wonder when that tipping point will come.
Well,
will.
I'll tell you, Paul. Yeah, I'm going to go to you in a minute, Amy. But I will say, I felt this way when I was 30 and I was coming into ODR. Is that there were all of these incumbents who were skeptics and they were blocking my way. And I remember giving presentations to senior partners at law firms and them just crossing their arms saying, yeah, okay, this is never going to happen, nerd. This is your dream. And I remember thinking, I just have to wait for them to die. And they did. They died. And now the people who are in those chairs are much more open to it. So there's no way that you can, your description of the arbitration field, Paul, that to me is the entire legal field. It's the managing partners, it's the judges, it's all of it together. The law is made as a monopoly to resist these kind of competitive pressures that are making medicine and finance and everything change. But eventually the waves lap at the walls long enough, the walls fall down. And it does seem to me that that is happening, but it's taken a very long time in this area compared to other areas of society. And I know, Sophie, you want to say something, but Amy, please go first.
Oh, just what you're describing is diffusion theory. I mean, that's what we're seeing happening in real time. The idea of diffusion theory and this turnover, right? And we're starting to see signs of it. As you mentioned, the waves are going against the wall. Well, they're starting to erode the walls. And examples include what we've been talking about for the last since the beginning with ArbTech and with conference and all the different things happening. But also I see it with students and the next generation, right? And we're even seeing them discuss virtual arbitration in contract provisions, and where the contract provisions actually specify and allow for virtual arbitration. Now that helps a lot with the enforcement and the question that was posted in the chat, because that answers the question when you deal with enforceability. And I'm seeing a movement in that direction, but there's still some sort of holdouts. I think, for example, the managed care associates in the United States case, where they held that with online arbitration, with a virtual hearing, that you can't get discovery from third parties because there's no hearing, quote unquote, before the arbitrators because you are virtual. Now that's a very antiquated way of thinking. Now that was 2019. I think that if that were case decided today, and we're starting to see cases actually coming down the pipeline where they disagree and they say virtual arbitration is the same as in person, it's just a different venue, it's virtual instead of physically and before the arbitrators. So just those are examples, evolution of the law and what it is to be before the arbitrators, but also, like I said, provisions and contracts and the next generation, and looking at what students care about, what they're excited about. And that to me is very exciting.
Sophie, did you want to say something?
I will always want to say something if you give me the floor, but let's move on.
Okay. Well, I also I'm eager to get Neil's input because he does represent sort of the future of all of this as a younger generation. I think one of the differences being in Silicon Valley and seeing particularly all this, I want to talk about blockchain in a second and the nature of your disagreement, Paul and Sophie. But the thing about blockchain is these systems are incredibly disruptive, incredibly future oriented, and they're being built by 30-year-olds. And these are people who they're not willing to spend the decades to work their way up through the incumbent avenues of power. They're going to build a completely new system that works the way they think things should work moving forward. And, to me, that's the way true disruptive change happens. How far would Airbnb have gotten if they were selling to Hilton and Hyatt? How far would Uber have gotten if they were selling to the taxi associations? If you build a totally new system and then you refine it and improve it, people think, well, that's just some crazy experiment that some 30-year-old is doing. And they're like, wow, maybe that's actually pretty great. Actually, that's better. And then all the volume goes over there. So let me ask, and Neil, I'm going to come back to you to talk about some of the generational stuff. But Paul and Sophie, what is the nature of your disagreement about blockchain in terms of its relevance to arbitration? One of the questions I had in my list was, what percentage of blockchain is real and what percentage of blockchain talk is just smoke? So you might have a difference of opinion on those percentages.
I mean, I think
Sophie,
Paul should,
you go first.
Paul should start. I mean, so that I can then absolutely destroy him.
All right, okay. Paul, good luck.
Okay, fair enough. My feeling, I said this at the photo conference, when we had a section on blockchain, is I feel in general about blockchain as though it's kind of like bell bottoms and platform shoes. So, it's right now, it's all the rage. Everyone's into it. Everyone will be into it for several years. And then next decade we'll be embarrassed we even had anything to do with it. And we'll leave it from there. So we don't have the time, I think, to rehearse all my objections to it, but I have both a general objection and a specific arbitration-specific objection. So actually, let's do the arbitration-specific objection first. I think blockchain actually is developing, and Sophie will tell you, I'm sure, some really interesting mechanisms for resolution of disputes on-chain about blockchain. I struggle still to see what the relevance of blockchain is to international arbitration more generally. And I know there are a number of disputes about trading platforms that have arbitration clauses in them and that are now going to be arbitrated. But again, that strikes me qualitatively as no different to any other kind of trading platform for a security or for anything else. So what is so fascinating about blockchain in that for arbitration, I don't get. Blockchain generally, I see that it is a fascinating regulatory issue, and I see there are all sorts of interesting regulatory developments about developing about whether it's security, whether the SEC or the Financial Conduct Authority in the UK or whoever should have jurisdiction over it. All very well and good. Again, at bottom, I just see, and forgive me for being just a thoroughgoing skeptic about blockchain, I think because the architecture in the end depends upon either mining or staking a cryptocurrency, whatever the cryptocurrency might be, whatever the application you're using, I think in the end, it depends on the value of that cryptocurrency. And to me, the architecture can't survive once people, as I think they will, eventually shrug their shoulders and say, why on earth are we bothering with this? What does it actually do? Now, Sophie, tell me, destroy me and tell me why I'm completely wrong.
Goodness, where do I start? Right, more seriously. So blockchain is a trend, so blockchain is a trend. I don't think this is a relevant consideration because at the moment, people are transacting. These people are anonymized and behind, but they are transacting. Money is exchanging hands. Money, value is exchanging hands. Potential for disputes. Potential for disputes means potential and opportunity for dispute settlement. So the bubble of blockchain may be the bubble of blockchain, but I don't think that's a valid basis to discount it. On the contrary, I think we should be wise as an arbitration or ODR or dispute resolution people to make our way in and make ourselves relevant to that arena so that in its later incarnation, whatever it might be, they will remember that we match their values, that we were able to deliver dispute resolution outcomes that were relevant to them. And this, my friends, is not arbitration as I practice it. It is a different kind of dispute resolution system, and we can talk about that later. Now, Paul has alluded to the applications that allow for dispute resolution on-chain. Kleros is one. There are others, which is peer-to-peer dispute resolution sitting on top of Ethereum. It works very well in an ecosystem that shares those values, that trusts the judgment of peers. That's fantastic. How that translates off-chain is an open question, absolutely. But at the moment, what matters is that these people are trusted in the communities in which they are offering their dispute resolution services. The outcomes are fair enough as far as that community is concerned. They don't need to have bells and whistles due process. They want to have an outcome within hours, within a day, so that they can carry on transacting. Arbitration as we practice it is not providing for that, and it should. It should find a way of making itself relevant to those values. Now, Paul says, I don't see how blockchain is relevant to arbitration. On Monday, there was a Law 360, I think, is the publication in the US that is the equivalent of GAR. published a very interesting article, not least because they quoted me, about a class action arbitration that where the lawyers, I think they're based in LA, and they're suing PayPal and Amazon for retaining monies that for breaching terms and conditions without giving any reasons. And so they are starting a class action against those those giant platforms. And to sort of gather the class, they're using the blockchain. They are giving a token to everyone who wants to be a claimant. And so my thinking is that's a very clever use of blockchain, the distributed ledger technology, which is good for doing exactly that, for gathering people who are, on chain, who may have had that problem and who are going to be, it's a much more efficient way of gathering a more comprehensive class of claimants. I mean, I'm not a class action lawyer, but I would imagine more comprehensive class of claimant than the usual ways of doing it by mainstream media. So I would have thought that blockchain has its use. What I have posited in the article, and I'm going to pause it here, but I was asked to project, which I don't like to do because you're going to fall flat on your face at one point, but within the next 5 to 10 years, blockchain as an immutable recorder of transactions could be, for example, a huge saving of money and time in terms of document disclosure. If you have, for example, a lot of things that I do have to do with infrastructure and construction disputes, very document heavy, and you spend tons of time going back to the documentary record of where things started to go wrong in the reports. If the players agree to put all of this on the blockchain as the project happens, then if ever a dispute arose down the line, a lot of time and effort looking for the right document to find out where things went wrong would be saved because it will all be there in real time. I think whether this happens or not is nothing to do with arbitration practitioners or even online dispute resolution practitioners or providers. It is to do with the users. Once the users understand that this is going to save them a huge chunk of this document disclosure time, then they might start thinking about using blockchain for the disclosure process and for evidence gathering as well. There's a potential, but I would say that the blockchain providers have to make a better case for the use of their product for these, because lawyers, users, when people are in litigation, they are, risk averse and very emotional about everything. You want to have a platform that will not be hacked, will be as tamper-proof as possible. And I think the blockchain maybe has not seen that business opportunity, but I think there is a real business opportunity there that will respond to the needs of lawyers and of users. And once you have that dialogue going, there's a real opportunity. So I agree with Paul that there is a lot of hype about blockchain that is not making it helpful to see the wood for the trees. But at the same time, if you put all of that aside and you look at it in a very sort of measured way, there are areas where it could be really helpful.
That's great. Amy, I know you've written a lot about this. What do you think about, what's your assessment of where blockchain is now and its relevance to arbitration?
Yeah, so I guess I'm sort of somewhere in between in the sense that I think it absolutely has some uses that could grow. But right now, I do think there's a lot of hype, for example, NFTs and some of these other areas that are sort of overhyped for what they really are. But I do think there could be some useful use cases that are going to gain more steam. For example, I'm more the smart contract aspect I think can be quite exciting. For example, we saw a proposal come out of Germany, and I think it's starting to be in play in terms of automatic enforcement of delay claims with respect to airlines and using smart contracts in order for that to happen automatically. Things like that create efficiencies and help consumers at the same time, at the same time, they're saving airlines money that they would otherwise have to deal with those particular disputes. So automatic payment systems, automatic enforcement systems that could be built into the process, I think is pretty exciting. As you, Colin, and I wrote about some years ago in 2019, creating this kind of emergency alert system, the odr button, I guess you called it, from Japan. But this idea of essentially tracking smart contracts and then building in a process for resolving disputes before you end up in a situation where all the money is stolen or something along those lines. I mean, I think there's different creative processes that could be out there. One of the things with OArb and with online arbitration that frustrates me is when everyone is just talking about Zoom and replicating what already exists. I feel very strongly that we have to reimagine the process and be more creative. And certainly there are ways that we could build smart contracts into the process to make it more efficient and to make it more user-friendly. And even with digital identities in some cases, that could be particularly helpful.
Yeah, I'm with you, Amy. I think I'm in between both Sophie and Paul. I think the hype around blockchain far outpaces the reality, the way that exists today. But when I look at these projects and I look at the bones, I think, wow, this is the beginning of the trust architecture for Web3. The innovations that are occurring in this space is going to help us realize where I think all of this is headed, which is the software, the code becomes law. And, I think Satoshi Nakamura, when he created blockchain, he was just trying to solve a trust problem for he had a broader goal, and this was just one means of achieving it. But this idea,
Colin,
they, right?
They.
Yeah.
But
yeah.
you still. So I'm sorry, Colin. Didn't mean.
No, please. I'm done. What were you going to say? I want to pivot to the data conversation.
Okay.
Yeah.
Okay. Well, fine.
No. But make your final point. We'll give you the last word.
My final point is the architecture, the trust architecture is fascinating, but I think you still have the paranoia that Satoshi and others had, and this sort of anarcho-libertarian nonsense surrounding it, that at base, what you are staking or mining is a cryptocurrency. And unless and until people, I think, start to, you could use yuan or dollars or whatever at the base of that, then you're going to have the question about how much value that cryptocurrency really has,
right.
And whether it's a big giant Ponzi scheme, and whether therefore at some point people are going to throw up their hands and say, there's no point, I'm making no money out of mining this or staking it, so screw it, and the whole system collapses. That's my problem with it.
Yep.
But Paul, I mean, not all tokens have value. So you have, for example, in the class arbitration thing, the token has no value. It's just a means to get yourself into the. So crypto is. You're absolutely right that crypto is its own planet, and it has its own problem. But I think we have to be.
We've got to steer our way.
Yeah.
Yeah. Well, all the fog
to associate
of the,
everything from blockchain with crypto.
Yeah, pardon my French, but all the shit coins and the NFTs and all of this blah 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 pink fog. We've got to get through this, and then we'll see what's real out of all of this. But in terms of my looking at it, there is a real there. There's a there, and I actually think blockchain, independent of all of the virtual currencies and decentralized finance, it still has some value for us down the road in this new decentralized justice. Code is law. Next gen.
I think
you're unconvinced, Paul. You're unconvinced.
Yeah. I'm yes. Sorry. Go ahead, Jim. I wonder whether
there's a question from Jim. I wonder if
Jim, I love you like a brother, but we only have a limited amount of time, and I want to get back to the data conversation. So I think we squeezed a lot of juice out of this particular lemon. Let's switch to the orange. So, and the metaverse thing, to me, I'm a skeptic about that, the way Paul feels about blockchain. I feel like there's so much FUD about it now, and it's the same conversation we were having 30 years ago. So let's not talk about that. But I do think that AI and machine learning is becoming more and more real. And I think you look at DALL-E and you look at OpenAI and you say, wow, this is really going to transform society. And I think all of us who know the way AI and machine learning works knows that it's not about the code, it's about the data. And I just wanted Debi to, for you to share your perspective on, this data gathering effort that you're engaged in. Can you just give us sort of 2 cents of why you think this is important and sort of how this is relevant to the future of arbitration?
Well, I think it's relevant because there are, in all areas of business, data is being used to make decisions and to look at where the future is going, and the legal world is behind in that view in terms of actually getting lawyers to look at data. I think it's just starting. I think we're starting to turn the corner there, but it reminds me of when mediation was coming in to our world, and there were people were saying, mediation is never going to work, and it was a long tail before we actually got to the point where mediation was useful and people could see the value of it. And I think the same is true for data. I think there has to be a lot more educational efforts in data, and we have to see a lot more evidence of how it's used. And I think the other thing that I know, particularly one of the challenges that we have with dispute resolution data, is that in order to get people to share their data, we had to guarantee a level of confidentiality. And that level of confidentiality keeps the data from being as useful as it could. So I think that's another that's another hill that we have to climb.
Well, I think they say the future of the internet is not about money, it's about data. And that's why Facebook, they don't want your money. You could say, look, don't gather my data, I'll pay you $100 a month. They say, we don't want your $100. We're gonna get a lot more money selling your data. So do you think that the arbitral institutions are becoming more cognizant of this risk and getting a little more proprietary? I mean, because I think that this data is going to be really valuable one day, but it has to be structured. I mean, somebody needs to do, and I think a lot of these arbitral institutions are generating a lot of data and then just not doing anything with it. It's just kind of sitting on their hard drives.
That's true. I think actually that they are becoming more open to sharing their data, but it's still that they're sharing, they're sharing awards, but they have to be approved by both parties. And if there is no approval, they have to wait 6 months. So the other issue is that the data is not current once it's out there. Which we're used to that. We've had that for quite a while, where you can look at cases but they're in the past, and that's one of the issues that we tried to work around, is to provide current data just on a daily basis, so that you could actually look at where a field is, or where a particular case type or decision-making process is today, rather than 6 months ago or 2 years ago.
Well, I know from all the presentations I do about ODR, I mean, if I had a dime for every time somebody asked me a question about, are you building digital arbitrators? I said, no, that's not what we're doing here. I mean, maybe way down the road, but there's no way that you're ever going to get to anything like digital arbitrator without a really large data set that you can use to train some algorithm on. And I don't know who's putting that data set together. I do know that it seems to me Lexis and Westlaw and some of these companies are thinking about that. Like, let's get this data. We don't know what we're going to do with it, but we know it's going to be valuable one day. So they're making acquisitions and moves in that area. But let me just throw that out to everybody. I mean, what do you think about the relevance of AI machine learning in OArb? And is this like we were talking about with blockchain? Is this a lot of fog and it's all in the future, or do you think this is going to be happening in the next 3 to 5 years?
I'll jump in, and I see Paul. Paul, you go ahead. I just saw you unmute.
Well, it won't shock you to learn that I think it's not nearly as foggy as blockchain, but or indeed the metaverse, because I think we are starting already to see it in arbitration or around the contours of arbitration. So there are a couple of services that purport to offer AI for arbitrator selection, for example. Query, whether there really is enough of a data set at this point, given the few thousand decisions that we have published, to give this some accuracy. Although, as I understand it, the algorithms are getting more able to work off smaller data sets, but. I think we are beginning to see it. I think we will see it at the margins. Certainly the case law, the US case law, is plenty big enough to be able to do that. So you might find things involving various various states. English law is also big enough to do it. So you might see the sort of expert legal functions intruded upon by AI in arbitration, maybe, and again, if arbitration gets its act together before you see it in the court system, you certainly see it in document production. You've seen it for a decade in document production in courts, and you see it now in arbitration as well. And I think the other, you can tell me if this is not relevant, I think the other way in which we might begin to see it as sort of a tangent is in witness examination, and I'm thinking about automated systems of sort of facial expressions and things like that, and telling us if we're telling the truth or not, and that sort of thing. That maybe it's slightly at a tangent, but that's about big data.
I think arbitrators having AI-based tools in their toolbox to say, watch this video of this witness and score it. How likely do you think that they're being honest? Or submitting a document or a lot of documents and saying, how, do any of these seem fabricated to you or inauthentic? I mean, those are kinds of things that AIs could be good at. And it's not like we're putting those AIs in the arbitrator's seat, but these are tools that arbitrators could use in their practice. Amy, what did you want to say?
Yeah, absolutely. I agree with that. And we already see it. So, I mean, you have functions like Lex Machina and others, you have brief analyzers, you have law firms investing lots of money into developing their own AIs in-house even. And I absolutely think that you're going to see arbitrators using more and more data analytics and AI in their practice. And I wouldn't be surprised in areas that are more discrete. For example, patent decisions. Lex Machina is quite apt in predicting patent because there's enough data. And when you have more and more data in particular areas, you're going to see more and more use of AI. You also, for example, at the Cyber Justice Laboratory in Montreal, they're just, creating this justice bot and other types of uses of AI, natural language processing, being able to take a picture of a document and upload all the information into the relevant spaces. I think there's just a lot of different uses that are going to explode. I really think that's going to happen in 3 to 5 years.
Sophie, do you agree with all this?
So I don't have a problem with an AI arbitrator. I think for certain disputes, an AI arbitrator can provide access to justice that is very valuable. In the arbitration that I practice, AI has a very important role to play. So I co-chair the ICC working group on allegations of corruption in arbitration, and AI has been deployed in the area of public procurement to find out where there was abuse of public funds. I can very well see a similar algorithm. I'm not a coder, but I can imagine conceptually a similar algorithm finding out where red flags or the possibility of red flags might sit. Now, obviously, introducing that into the arbitration field throws up a lot of questions. How much can I trust it? How can I probe it? But it does mean that you have an intelligence as a panel that you didn't have before. And so I actually, my take on this has always been that we can optimize the arbitration proceedings or the arbitration process by partnering with AI and drawing a line under what it can do and cannot do. And that drawing of the line is the difficult bit, because
and that's a moving target, right? Because what it can do today is different than what it can do next year. Yeah, absolutely.
And it is and not being overwhelmed by it and influenced by it as a decision maker is a real challenge. But I think if we are going to optimize the process, I think AI can do things that are they do things much better than the human, and we do things much better than AI. And the idea is to partner with them. And so I think AI is a fantastic option I'm not convinced about the witness credibility function of it. It may be that I haven't been exposed to it, but I would be very interested in seeing more AI solutions in the outcome of evidence that is very volume heavy and that eludes most, human brains, definitely.
And Debi, let me give you the last word on this particular topic. I mean, do you hear an openness on the part of the arbitral institutions you're partnering with to asking these questions and thinking about this? Are they connecting the data to the emergence of AI? And is this an active priority for them? What do you see in this space?
I think it's too early to tell right now. I think they know that their data has value, so they're figuring out what they can do with that. And I do believe that they would be looking at, if you look at AI in a arbitral institution, it's kind of like what Sophie was saying. You have to figure out where the line is. When do you need, and because the arbitral institutions they're human based right now. All the arbitrators and the whole service is based on personal service by an arbitrator. So where does AI fit in there?
Yeah, and that may be very disruptive and frightening to them to think about what that next stage looks like. Creates competitive vulnerabilities. They don't have that expertise in house. All right. Well, look, okay, Amy, what do you want to say?
Really quickly, some of these, there's regulations in place about facial recognition software. So I'd be a little skeptical about use of that for credibility. I just want to note that as a
regulators are going to drag their feet, definitely. Well, I would love to do this for another hour, but I want to respect everybody's time. But I want to give Neil the last bite at the apple here, because Neil, you're going to be the one who's going to be practicing after all of us are retired. I just said earlier, we just have to wait for them to die and get out of the way. Well, you are in the position of waiting for all of us to die, and then you can take over. But what do you think about where all of this is headed? I mean, you're in a very interesting spot editing Arbitration Today and arbitrate.com. You see all the news every day. Do you think there's an openness? I mean, what do you think that the younger generation aspires to do with the arbitration field moving forward?
Oh, yes. No, this is definitely an interesting issue that we are dealing with. And I mean, I'd love all of you not to die. I would love to have everyone around forever. But life moves on. Technology is going to evolve. So we will have, what I find very interesting and also challenging is this tension between the technology of today or arbitration today and what arbitration and what technology will be 5 years from now, 10 years from now. I see blockchain or AI driven judges as something way out in the future, maybe 10 years from now. I would love to have it today, but we are not there yet. So maybe that is something that we can put on pause or keep an eye on and wait for technology to catch up. But as we discussed, there are a lot of tools that are coming in from AI, which rely on machine learning to assist with legal processes. So the facilitative part of technology in arbitration is picking up big time, whether it is in choosing arbitrators, whether it is in reviewing documents, especially in big document-heavy arbitrations, the commercial complex disputes, or even construction disputes. And there are quite a lot of tools out there. I think there are legal analytics software. I think Premonition is one, which goes into all the documents that are there and can give you an evaluation of what's going to happen or what is likely to happen. And the same kind of technology can be used for research and drafting. All the time and the hours spent on going through tons and tons of cases and documents can easily be done by AI. And this is what I feel is going to kick in. I mean, it's already kicked in, but it's going to kick in quite a bit over the next few years. And this is something that we need to be aware of and get involved in. And maybe 10 years from now, we will have an AI arbitrator, but it will all come from the work that we are doing today.
Absolutely, absolutely. And I think that's probably where we'll leave it. I think that, we have a lot of forward-thinking minds here. It's very interesting to think that we might be able to nudge things one degree in one direction or the other and think about what's the impact of that, down the road when 10 years, when we have that digital arbitrator. I think a lot of the foundations we're laying here are going to shape the eventual height of the building. But I want to thank everyone for joining this conversation. This is fascinating. This was a great discussion. It exceeded my expectations, and I had very high expectations. So thank you so much for joining in. And I will post this recording so that others can benefit from our wisdom as well. So
Thank you for having me.
Yeah, thanks for having us. Thank you,
Absolutely.
everybody.
Thanks, Colin.
Thanks.
Keep up the good work. Yes, live long and perspire. Yeah. All right. Take care, everybody.
Bye-bye.
Bye-bye.
Bye-bye.